Okay, so continuing with the theme of where are we now? Oh, there we go. Continuing with seeing the Shavuot's coming up in a couple of days' time. Let's continue with some more halachot and facts relating to the Chag. Okay, let's continue here. I don't know where I left off. Okay, we left off the Shavuot meal. First day is dairy meal, and second day is a normal Chag surah, like with meat, etc. Okay, so staying up all night. Many question whether a person who remains awake the entire night is obligated. Oh, we did that, so apologies, guys. Okay, there we go. A similar question existed regarding the Birkat Torah. Common practice is to fulfill the obligation by answering Amen to the brachot, even if you stayed up through the night. This is what they're talking about. One shouldn't recite Amen after the phrase La Asok B'divrei Torah, but after the paragraph V'ha'arev na is completed. I don't know where that is. So that's probably in Pesukei de Zimra. It is likewise unclear whether one who remains awake all night may recite the brachos of Elokai Neshama and Ha'marev Sheina Ma'enai. Yeah, as well, common practice is to find someone who did sleep the previous night and answer Amen to that individual's brachot. Amen following Ha'amaver Sheina should not be said until the bracha that concludes the Yehi Ratzon prayer. Okay, hold on a second here. Okay, Shavuot davening. Staying up late to learn Torah doesn't exempt one from reciting Kriyat Shema in its proper time. The mitzvah Kriyat Shema should ideally be fulfilled during davening. In order to recite Kriyat Shema together with the birkot, the brachas of Kriyat Shema, and not beforehand. Rav Soloveitchik and many poskim maintain that it is better to daven without a minyan before Sof Zman Kriyat Shema, the end of the period up to when one can say Shema, whether it's to get the bracha, to say it in the correct time, rather than daven with a minyan after the time has lapsed, after the time has lapsed to say it. Many have the custom to follow the Balatanya's practice to recite Ushnei Se'irim Lechaper as opposed to V'Sa'ir Lechaper. In the Musaf Amidah, in order to make mention of the Korban Chatat that was offered with the Shtei Halechem, the two showbreads of Shavuot. Megillat Rut is also read on the second day of Shavuot. In Israel, it'll all be on Sunday. The custom is to reread the Megillah from a klaf in certain communities. Poskim differ as to whether the brachot of Ala Mikra, Megillah, and Shechiyanu are recited when a klaf is used. Now, we don't usually do that. I've never seen that. Not that I stay awake for it, but that's usually read from a chumash or a siddur. So, okay, there's other stuff we can do next time.
Thanks, Kabb. Okay, so does everybody know Abaya and Rava's argument off by heart, or can I go through it for 3 minutes?
No, you do.
All right.
Yeah, well, at least one person here does.
At least one of us in the group does. That's pretty cool.
Yeah.
All right. So, guys, remember this. The Gemara cites an Amoraic dispute regarding Zomamim conspiring witnesses. So it's been stated, one who testifies and is subsequently found to be a Zomam witness, a conspiring witness. What's the situation? Abaya says he's disqualified from serving as a witness retroactively, which means in every case beforehand, from the moment he testified. And what do we mean? We basically mean that, for example, if there were two witnesses that testified in January, and subsequently they were exposed as conspiring witnesses in February, they become disqualified even from their testimony in January, from when they started giving their testimony. Any other testimony they gave in the interim is also invalidated. That's according to Rashi. Okay, so that is automatically quite clear to us. By the way, the halacha does hold like a buyer. In 6 cases, this is one of the 6. But the rest of Shas, you must know, goes according to Rava. So Rava's big guns too, believe me, as exactly as a buyer. Now, what's a buyer's position on this? He's saying that the conspiring witness is disqualified from serving as a witness only from now. In other words, when he's found to be a lying witness onward. Okay, so what we're basically saying is any testimony that he gave, or the 2 witnesses gave that were false in other cases up to that time, where they were actually proven to be lying witnesses, remains absolutely valid. So Abaye and Rava in this particular Gemara actually discuss a case of a single zomain, a single witness, because what they want to do is they want to parallel the verse in Deuteronomy, Devarim chapter 19, verse 18, which also discusses a single witness. Okay? Now, there is a prohibition in Shmot, which is Exodus chapter 20, verse 13, that you shall not bear false witness. Okay, and how does this relate? It's because this is the grounds for their respective opinions. Abba says he is disqualified retroactively because from the moment he testified falsely, he became an evildoer. Obviously from Shmot chapter 20, verse 13, we know that although 2 Zomamim, witnesses say that they were present, we don't view the situation as merely their word against those of the 2 witnesses that seek to discredit them. And Arthur explained it quite nicely last time, he remembered, that it was implicit in the Torah's command to punish the Zomamim that we believe the testimony of the second set of witnesses that were basically testifying that the first set of witnesses couldn't have been at the scene of the alleged crime. Why? Because, say, the first 2 set of witnesses came and said that John Smith committed a homicide in Johannesburg, and there were witnesses that came to witnesses and said, well, these first 2 witnesses couldn't have viewed such an incident in Johannesburg because they were on the beach with us at a braai in Cape Town. So this in turn establishes the Zomamim, the witnesses, as having given false testimony and are established to be evildoers, basically. Okay. Now, the Torah further has a statement that says, do not place an evildoer as a witness. Now, that's going forward. That's not in the 20th verse of Shmot. That's in the 23rd verse of Shmot, the first... it's not the 20th chapter of Shmot, it's the 23rd chapter of Shmot, and the first verse. So the exact verse actually says, don't place your hand as an evildoer to be a corrupt witness. So when we learn it from the Talmud, we learn that that verse actually means to bar the testimony of an evildoer. That's all it means. Okay? So in that particular case, Rava said he's only disqualified from now onward because the discrediting of Zomamim witness is a novelty. Guys, can any of you remember why it was a novelty? Kev, go for it.
You did tell us. I know you told us. The discrediting of the witnesses is a novelty. For who?
Yeah. Well, the concept for us is a novelty, but why?
Now I remember you told us. You did tell us. Because it's a chiddush, it's a new concept, something that maybe we...
Yes, but what is that chiddush? What is that novelty? What's... I want to see if you do remember. If you don't, it's not the end of the world.
Let me just give me 10, 20 seconds to see if I remember. Yeah. Otherwise, Gavin will have to try.
You better get it, Kevin.
No, can't remember.
You're under pressure. Keep trying, Kevin. Keep trying. I've got all day. Sorry, Damon, I didn't actually hear the question. I actually went to, I was doing my back. It was so sore, and this ice pack, I went to put it in the freezer.
I know, that's why I asked Kevin, not you, because I knew you ducked. but it's not a problem. I knew it was medical. Well, I probably bored you, but we put it under the reason of medical because I created your own medical illness. So, what from stress? So, what we're saying is that why does Rava hold that there's no retroactive punishment of conspiring witnesses?
Because of this novelty thing, but I'm trying to remember what it is.
What is the novelty? That's what I'm asking.
Yeah, no, okay. I'm with you. Let me try to think back. I'm just going to go into my archives. Give me a second. Because of novelty again. I don't know. Just refresh us. I do remember, but I can't get it wrong.
No, it's not a problem. So this is the novelty. It constitutes an exception to the normal rules of evidence. Why? Because if you look at the reality of this situation, there's 2 against 2. What do we mean there's 2 against 2? It's implicit in the testimony of the first witnesses that they were present at the scene of the incident. That's number 1. And then if you have another 2 set of witnesses that testify that this first set of witnesses were somewhere else at the time of the incident, then why are you necessarily believing the second set of witnesses? Because the Gemara says, maybe you want to heed instead these first witnesses who say that they were present. So in other words, what we're saying is, logically, you've got 2 contradictory testimonies. The first witnesses say that they viewed the murder in Johannesburg. The second set of witnesses are turning around and saying, these witnesses are saying those first 2 that said they witnessed the homicide couldn't be because they were in Cape Town with us at a braai. So what rationale is there for believing the second set of witnesses over the first set? Logically, if you've got 2 sets of contradictory testimony, they should cancel each other out if there's an even number of witnesses. And this is even brought in that capital case of Sanhedrin in the 27th daf. Okay? So that's actually the chidus. So therefore, since the law that we believe the second witnesses and discredit the first ones is a novelty, it's not by logic, you can only apply it from the time the novelty takes effect and onwards. In other words, from the time the witnesses are exposed as conspiring witnesses. So since the law is scriptural in nature, it's from the Chumash, that constitutes an exception to the ordinary rule of testimony. Okay? And it's not a logical extension of them. And therefore, because it's not a logical extension of them, it has to be applied with a diet, with a limitation, in a limited way. Only from the moment the novelty goes into effect, in other words, when they're exposed for the liars they are, these witnesses, is when the discrediting witnesses actually testify that they couldn't, the first set of witnesses couldn't have been at that location. So any testimony that the first set of witnesses gave from the time of the original testimony until they were actually proven to be false witnesses, that remains valid. Okay, so that's a novelty.
Yeah.
Now, there's another rationale for Rava's opinion. There are those who say, Rava also agreed with the buyer who says that the Zomamim witness is really disqualified retroactively from the moment he testified. Okay? So whether we use the word Zomamim as in the plural of the 2 witnesses being discredited or 1 witness, the only reason in this Gemara again that it represents the singular witness is just because it has to follow that pasuk in Deuteronomy chapter 18, verse 18 and 19. It's just consistent. But whether it's 1 or 2, it doesn't matter in the sense that if you've got an even number of witnesses against each other, then they should cancel each other out. But according to the scriptural verse, we believe the second set of witnesses. So then we understand why Rava applies a limit, that from the time the witnesses are exposed as Zomamim, from then on their testimony is thrown out of court. But from the time when they actually started testifying, not so. But there has to be another reason for Rava's opinion, and this is it. There are those who say that Rava also agreed with the buyer who said that conspiring witnesses or a conspiring witness is actually really disqualified retroactively from the moment he testified, because he's made to be a liar. You can't believe him. And here, Rava's reason for the ruling that he became disqualified only from now onwards is the following, okay? It's because of concern for the loss of purchasers who, being unaware of his disqualification, used him as a witness on their documents. So what we're saying is, if you take monetary cases, say, for example, this particular case where there are two guys at the shul, at the synagogue, and the one bought a property from the other. And they called one of the guys at shul just to witness the document. And then 2 months later, the one witness that signs the document is found to be invalidated in a completely separate legal case. Any bill of sale witnessed by him between the time he testified falsely and the time he was exposed as a conspiring witness, for example, would be invalidated. So the buyer would have no way of proving that he indeed bought it. So in other words, we say in this witness, unbeknownst to the guy at the shul that just happened to use one of the random shul guys to witness this transaction, was involved in another case that spanned about maybe a month before the sale of the property took place. And when the second set of witnesses said he couldn't have been there to testify about this incident in the magistrate's court, any sort of contractual witnessing that he's done from the moment he started this trial, in any case, is said to be thrown out of court. We're going to have a problem here because that witness to that bill of sale has become invalidated. So the buyer would have no way of proving that he indeed bought it from the seller. And this wouldn't be any fault of the buyer. How was he to know that the witness would be a disqualified due to his lying in a different case retroactively? So therefore, to protect purchasers or any financial transaction of which is merely a witness and not a participant, the rabbis enacted that a zomeim, a conspiring witness, be disqualified only from the time he's actually exposed and on. So I'm assuming, guys, that what this means is that according to this other explanation of Rava, it might be that he agrees with the buyer that in this particular case he was proved to be false, that entire case is retroactively, according to the second opinion, not the first opinion of Rava, is retroactively thrown out the testimony, because then you can't believe this guy in this case at all. But that has nothing to do with him signing as witness on a separate monetary case. So that clearly this rabbinic enactment would apply only to monetary cases, because the rabbis can circumvent biblical law through their power to deprive people of their property and assign it to others. So in financial cases, they have got that authority. Okay. However, with respect to non-monetary cases, take, for example, capital cases where you're dealing with a murder or the case of marriage and divorce, the biblical law from the Chumash disqualifies a conspiring witness as zomeim retroactively, and that would remain in effect. In other words, any other case that this witness would be involved in that is really either a life and death matter or affects somebody's marriage or divorce, that would remain in effect, that there would be a retroactive cancelling out of that witness, according to this explanation. So, at least from Tosfot's point of view, that this rabbinic enactment would apply to all monetary cases, not just purchases. Okay, so what we wanted to know is, well, what does the effect of these two different explanations of Rava actually mean? In other words, what's the practical implication? Okay, so the first is where two witnesses testify against one of the original witnesses. Listen carefully, guys. The first case that I'm going to bring here about the practical difference between the explanation of Rava's first view and second view is as follows. Is that where there are two witnesses and they testify against one of the original witnesses, and two other witnesses testify against the other one, That's not a novelty, guys. And therefore, there's retroactive, even if you're holding according to the first opinion of Rava, there's retroactive disqualification. Why in that case? Guys?
Because there's no novelty, so that's why it's retroactive.
Correct. Why is it no novelty?
Two versus one there.
Excellent.
Two
that's the answer.
coming against one.
That's excellent.
Yeah.
So hear what Gavin's saying. Gavin, repeat it for the group. That's excellent.
So there's no novelty. So therefore, even with Rava, it will be retroactive because of the no novelty factor. Because it's not 2 against 2, it's 2 against 1.
Correct. So Kevin, since that's generally 2 witnesses cancel out 2 witnesses, or 1 witness cancels out another, because we said if you look at a marriage counselor and a couple comes to him, the wife's got her side of the story, the husband's got his side of the story, and the truth is probably somewhere in the middle. And they're both wrong and they're both right. So they cancel each other out in terms of whose side do you take. You've got to listen to both of them fairly. So it's not that one automatically wins. But here we're talking about if, say, for example, there's a bar fight. And the one guy said, I did nothing. And 2 guys that don't know each other said, yes, he smacked this other guy. You've got to believe them because it's 2 against 1. So since there's no novelty there, then the first explanation of why Rava didn't retroactively install the invalidation of the conspiring witness falls away. And therefore, any previous testimony that he's given, not only in this case, but in other cases, is struck off the record and basically disqualified. So that's an excellent explanation, Gavin. Now, there's another case. And do any of you remember the other case?
Do you just give it now?
No, from last time. What was the
previous
other
session?
Yes.
No, I can't remember.
Okay.
Go ahead then. Thanks.
So
I can't think of it now.
That's not a problem. You've done very well so far. Alternatively, where the second set disqualified the first set of witnesses on the basis of them having committed robbery. So what does this mean? That the second pair didn't expose the first pair as saying, no, they weren't in Johannesburg at the time they witnessed this particular incident. They were with us in Cape Town. But they turned around and said, listen, you can't believe this first set of witnesses. We're from Joburg, they're from Joburg. We don't dispute they were there. But they're not credible witnesses. They're gamblers, they're thieves, they're robbers, they're drug addicts, they're drug dealers. They can't serve as witnesses. They're disqualified. They're unsavory characters, as that saying goes. So the disqualification of the first pair is not a novelty, according to Rashi. Do you know what I'm saying?
So, Damon, so the novelty is usually it's 2 witnesses against 2. But it would be 1 against 2, or is that the novelty?
The novelty is 2 against 2 in the case where they're saying, well, where they were at the time of the crime. That's the novelty.
Oh, like in another city, and it was totally wrong.
Yeah. But in a case where the second set are not disputing that the first set could have witnessed it, they just said you can't trust these characters. They're unsavory characters. They wouldn't be eligible as witnesses because they're criminals. Then on that basis, we believe them because, in other words, the first witnesses are implicitly saying that they're eligible to testify and are not robbers. That doesn't constitute a contradiction of the second witnesses, because the testimony of the second witnesses, Kevin, in this case, does not directly pertain to the testimony at hand, but to the separate question of the first witness's eligibility to testify. So therefore, the assertion of the first witnesses that they are not robbers, is inadmissible because a person is not eligible to act as his own witness on his own behalf, according to Rashi. You can't be accused of rape and say, I'm not a rapist. That's why you have external witnesses to say where this person was. And just like a person can't defend themselves, a person also, that's how attorneys started. Is not in the small claims court, is that you needed legal counsel that could act on your behalf. You can't incriminate yourself in Jewish law either. So it works both to your advantage and disadvantage. It's a fair game. So that's unlike the Hazama case, because a Hazama is that concept of saying that the first witnesses are proven to be conspiring because the second set of witnesses, it wasn't an issue of the eligibility of the original witnesses, but to their truthfulness. So their statement that they were present at the incident should therefore count as much as a statement of the Hazama witnesses that they were not. And that's the novelty. But not in a case where the second set, because then it can cancel each other out, but not in the set when the second set of witnesses saying they were probably there, but these guys are arch criminals. And in those two cases where there's an odd number of witnesses, or they testifying to the unsavory characters, but not the issue at hand, in that case, Rava would agree with Abaya that there is retroactive disqualification of the conspiring witnesses. Okay, so, but according to the version that says that Rava's reason for not disqualifying okay, so guys, in each of the situations, according to the version that said that Rava's reason for not disqualifying a Zomaim witness, a conspiring witness retroactively, is because such disqualification is a novelty. That rationale does not apply in these cases, obviously. So Rava would agree that the first witnesses are disqualified retroactively in these cases, but according to the version that says that Rava's reason for not disqualifying a Zomaim witness, a conspiring witness retroactively, is because of something completely different, because of the concern for the loss of purchases. In that case, the rationale is applicable to these cases as well. So in other words, Rava would rule that even in these cases, the first witnesses are not disqualified retroactively. Does that make sense? Because we want to protect a person that had a witness that signed to the sale of a house, and in fact, it could undo that whole sale, that money was paid for that property because he happened to be embroiled in a different legal case. It's not the fault of the purchase at all. So that would still stand where it would protect the purchaser, and there's no retro, even if there wasn't a novelty, a chidush, where there wouldn't be a retroactive in a different case, guys, for monetary cases, disqualification. So the Gemara cites the ruling of some latter Amoraim on this incident. Yirmiyah of Difti said Rav Papa acted in the case that came before him in accordance with Rava's ruling. So in other words, Rav Papa goes with Rava on this. Rav Ashi says the halacha follows a buyer. Now, the Gemara's conclusion is as follows. We've only got 6 minutes. And it concludes the following, is that everywhere in Shas, the halacha follows a buyer, okay? Everywhere in Shas, the halacha follows Rava, everywhere, except in 6 cases, this being one of them, okay? So Rav Ashi disagrees, and he says the halacha follows a buyer, but the rest of the poskim in Shas say that the halacha follows a buyer, but Rav Papa says it follows Rava. So in conclusion, the halacha follows a buyer in his dispute with Rava, in 6 disputes indicated by the mnemonic. It's got Yud, Aleph, Lamed, Kuf, Gimel, Mem. So in other words, the halacha in our case follows the view of a buyer, that Zomamim witnesses are disqualified retroactively. It doesn't agree with Rava, but in everywhere else in Shas, with the arguments with the buyer and Rava, it agrees with Rava, except in the following 6 cases. I've got 5 minutes to tell you those cases quickly, and then we are done. Okay, and we'll be done before 5 minutes. So, the first case is our dispute here. The second case is a discussion of abandonment without awareness. Okay, what is abandonment without awareness? Okay, guys, there's a situation in which an object was lost under conditions in which the owner would ordinarily abandon any hope of recovering it. This owner, however, was obstinate. He didn't abandon hope because he was not yet aware that the object had been lost. So it seems like he wasn't obstinate, he just wasn't aware. In other words, it's only when you got the bad news that he's aware that the bad news occurred. Up until the point that he didn't get the bad news, he wasn't aware. So a buyer therefore maintains that it's not considered abandonment and the finder must return it. And Rava says that the finder may keep it because if it's technically lost, even if the owner isn't aware, the finder can keep it. But in this case, the halacha goes with the buyer. Okay? Another case is a lechi that stands by himself. What are we talking about here? Kevin, a lechi is a side post. So we learn in the 15th daf of Eruvim that say that there was a side post that was installed maybe for lighting, right? But it wasn't installed as a pole for an Erev. And it happens to be standing at the entrance of a Maivoy. It can permit carrying on the Sabbath, even though it was not put up for that purpose. So in that case, we go with the buyer. Another one in Kedushin that is not given to cohabitation. So what do we mean? Is that a guy's going to marry two sisters, but he never specified which sister he's going to marry. He made a mistake. He didn't specify. So now the problem is because he didn't specify, he can't sleep with either of them because it would technically be adultery on either grounds because he never specified which sister is married. So therefore, both of the sisters are prohibited for him. And therefore, there's a dispute whether the act of betrothal has any validity whatsoever. That's in the 51st daf of Kedushin. Then the other issue is where we go with the buyer, is clarification of intention regarding a get, which is a divorce. The issue pertains whether certain statements of a husband can be interpreted basically as a nullification of the bull of divorce sent to his wife. That's in the 34th daf of Gittin. And then another case where we go with a buyer, a renegade who eats unslaughtered meat in defiance of the Torah. So the dispute is whether somebody who eats non-kosher food, not for personal gain, not for pleasure, not that he was hungry, but simply in defiance of the Torah's law, is he eligible to serve as a witness because he's dafka? That's in the 27th daf in Sanhedrin, in a capital case. Be interesting in a monetary case, but certainly in a capital case is a question. So in these 6 cases, the halacha follows a buyer. In all other disputes between a buyer and Rava, the halacha follows Rava. All right, guys, we are done. I know that was a repetition of the other day, but we clearly all needed it, and it was not a waste.
Damon, what is this page 72 or still 71b?
Okay, so what we're dealing with here is 72b2 and 73a1.
Okay, now just Damon. So I still don't get this novelty. Can you just explain it to me one more time, please?
If you've got the first set of witnesses that viewed an incident in Johannesburg, and there's a second set of witnesses with an even number saying that they weren't in Johannesburg because they were with them in Cape Town. 2 witnesses arguing 2 witnesses should cancel each other out. Why should we believe the second witnesses? The Chumash says we do, not based on logic, but because it's a scriptural verse. Therefore, that's a novelty. The logic would tell us otherwise. We don't believe either, because either one could be right. And therefore, that novelty means we can only apply the disqualification of the first set of witnesses from that point on, not from previously.
Retroactively.
No, not
retroactively. Take the word.
You can't.
Going on to the future, you can't take them seriously. You don't take their word on anything.
Yes, because it's applied in a limited